And now we go to another hot topic, especially nowadays, with David Pitlarge, one of the partners at Hill Dickinson, who is going to talk about the contractual implication of Ebola. Thank you.
Thank you very much indeed. There is a change of topic, as you will have realized. I was slated to talk about paper warranties and terms concerning ISM and classification societies. If anyone wants to talk about that, I'm happy to do so over a drink later. But I think topicality is a key feature of shipping and the law, so I've switched this talk to the Ebola epidemic in the commercial shipping context.
David, I asked you a hot speech, but this might be a little bit too hot for my taste.
Well, you know my temperamental nature, Francesco, so you might have to back off a little. No, seriously, this is rather like Patricia's talk earlier. It was designed to be a little bit longer. I think I've got slightly more slides, so I'm going to race through them and try and alight on the points that seem to me to be important. The problem I think we are all aware of, and I think a key feature of it, is that it is fast evolving. As I was speaking on this last week in Norway, we had the first case in the United States of someone who found to have Ebola. The Times this Monday was reporting that there's a 50% chance in the UK, a 75% chance in France. Yesterday there was a reported case in Spain, although the Daily Mail, the mouthpiece of Middle England, was more concerned about what the fate of the poor lady's dog. But the fact is, it is moving fast. On the slide, you can see how some cruise liners have responded. The areas affected, certainly in the seaborne areas in the most recent outbreaks, are west of Africa, Guinea, Sierra Leone, and Liberia. So obviously there's some maritime activity there, of course. And as we shall see, one of the responses, of course, is port closures and quarantine regulations. An interesting feature of this is how the adjacent ports in West Africa, like Mauritania, Gabon, the Ivory Coast, and Cameroon, have been closed. So the short sea trades are inevitably going to be affected. West Africa, we also think of stowaways, a problem in itself, so that might too be part of the hazard that we will encounter, as it will be very difficult to monitor whether the stowaways have contracted the virus. Another response, of course, is enhanced quarantine regulations. I think one has to be a little careful. There seems to be a fair amount of urban mythology in this. Singapore announced that it was going to, with a circular, enhance its quarantine regime. When I first heard this reported to me, someone said it would be, vessels would be quarantined from 60 days from sailing from an Ebola port. In fact, as you can see from the slide, it only means that you have to wait for clearance if you sail from within 60 days, but it's still quite radical. Recommendations from supranational bodies. This, I think, is important because when we come to the legal side of this, the factual background, I think, is critical. Two that I've highlighted there are the World Health Organization and the International Maritime Organization. And I think there we're seeing a tension between the instinctive response to this, which is that it is something which we've got to respond in a very proactive and restrictive way, perhaps not trading to these ports. And what the World Health Organization and IMO are saying, and you can see it in their circulars coming out in September, and they say in the strongest terms, they even bold type that it does not recommend any ban on international travel or trade to the Ebola-infected areas that we've just looked at. Industry circulars are being, Mike Salthouse's presentation had a picture of a hapless club executive, if you remember, with papers either side of him. If you were to print off all of the material out there on the web, you would look rather like Mike's photograph there. But some of them are good, some of them are bad, but it is important to be on top of the, not only the factual story, but what the industry is recommending that you do, and I'll show you why. Another response is recommended clauses, and I will touch upon those shortly. Legal context. I'm a lawyer, so I should talk about that. This was a quote from the Saldana, a case we spoke about in the first Shipping and the Law 4 years ago now. The key point here is That was a case concerning detention for a lengthy period and pirates. Was that fair? Was it fair that the charterers should keep paying? Well, the counsel for the owners submitted that you don't look at fairness, you look at the words, albeit in that rather ominous phrase, construed in accordance with well-known orthodoxy. And that can be a rather elusive concept sometimes. So, I think in organising my thoughts in this, I think you have to sort of try to break things out, because there is a lot of material, you've got to digest it quickly. Distinctions I've found have helped me are, firstly, distinguishing between laws that apply in the relevant ports, and second, and from the laws that apply to your contracts, your matrix contract. Second, the position at the EBOLA port, largely speaking the loading port, but not necessarily, from that at the subsequent destination. The first issue, the EBOLA port is going to have a bearing on orders and compliance and performing the service. The second is probably more likely to express itself in delays. A lot of these issues come up, we've seen in the Arab Spring, in piracy, and going back in my experience to the first Gulf War. One of the starting points is port safety. Can an EBOLA port be unsafe? I actually think it's quite an interesting question, and certainly people whose opinions I respect a lot are divided on the issue. But I think the context is very important. You have to ask why you're asking the question and when you're asking the question. If you're ordered to go to, let's say, Freetown to load iron ore, you have something of a dilemma. If instinctively, caring for your crew, vessel, the stigmatization of your ship, you probably don't want to do it. But if you're asking that question before going to the EBOLA port and you make the wrong call, then you've repudiated your charter. We all know time chartering is a little bit of a cat and mouse affair. If, for example, you're on a relative to the market generous rate, you will be gifting, if you're wrong in making the call about an EBOLA port being unsafe, you are gifting the charterer with an opportunity to repudiate, and of course the chance to claim damages. If, however, you're asking the question afterwards, and you've suffered, let's say, delays or other knock-on effects, it's a less critical question. What do we think of the question? Well, port safety, there it is, the words of Lord Justice Sellers from the Eastern City. I think everyone has either received an advice or given it in those terms. But this, as you can see from the quote, talks about the particular ship and navigation and seamanship. They're marine risks. So the question arises as to whether a risk to the crew can make a port unsafe. And this is where the division of opinion is. We accept that risks other than marine risks can make a port unsafe. But in my view, if you look at the cases which go beyond marine risks, they talk about political risks. Look at them, the Greek fighter, the risk of a vessel being confiscated, the chemical venture, famous cases, missile damage during the Iran-Iraq war, the Saga Cobb, guerrilla attacks at Massawa. They've not concerned the crew. In each case, the vessel has been at risk. So you have some uncertainty, I think, and there are no authorities or well-known ones that will help you determining the question. You then have to consider whether there's factually a breach. And we've seen that the IMO is telling you to carry on trading. The IMO, Mr. Liras tells us this morning, is the global regulator for shipping. It's not just a forum. So if that is telling you to keep trading, even if you can say an EBOLA port could technically be unsafe, factually it might not be so. So making that judgment call might be a hazard. Technical points there. If you've gone, you've suffered loss, delay, stigmatization, you might still claim under the implied indemnity. If your warranty is only a berth warranty, safe berth warranty, then I think you've got real problems, because as we all know, safe berths are only unsafe if their characteristic is different from other berths at the port. Time is running on. Off hire. Obvious points, look at the clauses. I've set out on the clauses the standard wording. The Apollo is a case that I've seen come up in the newsletters. Topically so, 2 crew members contract typhus, the vessel is delayed in Naples, and the vessel was held to be off hire. But that was the case with whatsoever. The NYP Clause 15 does not have quarantine regulations. So looking at the words subject to the specific terms like shell time or supply time, and the principles that an off-hire will not arise where it's a natural result of charter's orders, I think there's probably quite likely to be on hire. The result might differ on the standard voyage charter wordings, and I think you have to again work through those. The WIFPOM provision, I think, of course, when you get there and you have to comply with quarantine regulations, then that is, unless you have a WIFPOM provision, is likely to prevent you serving an NOR, so you won't be, laytime won't run, you won't earn. The old case of the Saranikos entitled an owner to claim when no NOR could be served, but I don't think those facts would apply here. So I will move on. I don't think that breach of contract issues will arise. It's difficult to see how they would do. Perhaps if there was a delayed delivery claim, but you have exclusions under the Hague-Visby rules. But it's important that you comply with your due diligence obligations, and those will be shaped, I think, by the industry recommendations I've referred to. Keep up with your ISPS code observance. Specific clauses. There is no standard BIMCO clauses yet. I've seen a number of clauses coming from the likes of Vitol, BP, Trafigura, Mercuria. They're out there. Some are good, some are bad. Work out what you want to achieve, but be precise. I think, as I'm well over, I will leave it there. The key points. It will all turn on the contracts you have. There's no magic about EBOLA, as there was no magic about piracy or the issues before. Keep up to date with the facts, because those will shape those obligations. I think that's it. Okay, thank you very much.
Thanks a lot, David. You mentioned Vitol, Trafigura, Mercuria. These are all names I personally work with because I do the chartering on a daily basis. They do have EBOLA clauses. As you said, some are good, some are bad. I'm not going to say now which ones I prefer as a shipowner point of view, but I can tell you that the problem is this. You were talking about an unsafe port, especially on tankers. When we go there, we do STS, ship-to-ship transfers. And so the charter basically says, yes, but we are not entering the port, which is fine. Yes, we are not entering the port, but when you are there, you still have people coming from the port on board the vessel. So there could be a case of contact with these people. So in a way, the problem is still there, even if we are not talking a port. But that's just a kind of frustration I wanted to share with all of you. Thank you so much for your speech.